Metanomics is brought to you by Remedy Communications and Doosan Writers Metaverse.
Great. Well, good sign for the industry. I'd like to start by talking a little bit about terms of service, and as we mentioned in the segment with Sterling Wright, Raf Koster has been quite vocal on the importance of terms of service and takes pride in what they've put together for MetaPlace. I know that you can't comment much on specifics of clients, but what do you see as being the most important issues regarding terms of service, and are there any MetaPlace terms that you see as particularly notable?
So I think when it comes to terms of service, the biggest mistake that we see people make is that they try to copy someone else's terms of service, thinking that if an industry leader, for example, has a set of terms of service, that it should be usable by anybody. The reason that does not work, well, there's many, but one of the main reasons is that different virtual worlds have different business models and different legal issues. If you have a virtual currency versus if you don't, then different terms need to be included or not included. And even if you, for the sites that do have virtual currencies, there's different models. I mean, some don't really have a cash out, some you can only use in world. That's just one example. There's a whole host of issues that need to be addressed in a terms of service, and they each need to be thought through carefully in light of the business model of the particular virtual world and the nature of the activities that will occur in that world.
Mm-hmm. And so Doosan Writer has a question which I think fits well in a discussion of terms of service. What do platform owners fear the most when it comes to their legal obligations and relationships with platform users?
Well, I think there's a number of different things that they fear. I mean, one is that if they need to enforce their terms of service to protect their legitimate business interests or to protect their users from other users, one fear is that if the agreement is not properly written, that some or all of the terms may not be enforceable. One example of that, as you may be aware, when Second Life, they had a lawsuit, and one of their provisions, this wasn't one of the most substantive provisions, but they had an arbitration provision in their terms of service, and it was struck down as unenforceable. That's just one example.
That was the Bragg case, I believe?
The Mark Bragg case, yes. So, one of the things you want to make sure is that, it's fine to write terms of service, and you can put anything you want in the terms of service. If it's not going to be enforceable, you have a false sense of security. There was a recent case, I believe it was not a virtual world, but it was analogous in that there was a terms of service that enabled the service provider to change the terms at any time without even giving notice to the end users, and the court struck that down as being improper. So one of the key things that needs to be taken into account with terms of service is you need to balance the, kind of what you can do with what you should do and what's legally permissible, and then making sure you implement it in a proper way.